The implications of child custody decisions are far-reaching and can significantly impact the lives of both children and parents. It is important not to make mistakes, especially when parenting matters are before a court, arbitrator, or a professional parenting assessor. Since the stakes are so high for both parents and children, this episode of the Ontario Family Law Podcast will look at some big mistakes that parents often make but can easily avoid. If you are in family court over your kids, or worried that you may be, this will be an extremely important episode for you. I'm Schuman, a certified specialist in family law in Ontario, and I've been recognized for my concerns over children's law issues, difficult parenting cases, and complex financial matters. I'm also a mediator, arbitrator, and collaborative lawyer. I have a best-selling book, Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and in fine bookstores. If this episode covers topics that are important to you, you will likely find this book very helpful. I am going to get right into the big mistakes that people make in child custody or parenting cases. I have explained many of the legal concepts in other episodes, so I will just reference those episodes and focus on the main topic, avoiding mistakes that can lead to parents losing their custody case. 1. Using the term child custody. The first big mistake is asking for custody of the kids. Canada got rid of the term child custody in 2021. It no longer exists. I explain why in detail in episode 59. That episode also explains the law that applies in these cases. My book covers that information in detail. The term child custody puts too much emphasis on the parents and treats the kids a little like objects. It also turned the kids into a prize. Parenting professionals stopped using the term custody long ago. Family court judges were eager to follow suit. They wanted the focus to be on what the children needed and how to make sure the children thrived after separation. So the term custody is out. Now we talk about parenting time and parenting responsibilities, and the focus is on what is needed to make things the best possible for the kids. It is very important to take the right approach, so check out episode 59 or my book. Using the term child custody makes a parent seem selfish, uncaring about the children's needs, and focused on winning rather than caring about the children. These are all reasons why a judge might take the kids away from a parent. So that is definitely not the impression that a parent wants to make. Stay far away from the term child custody. 2. Putting the parents first. From the move to throw out the term child custody, it is clear that the law is more concerned about the kids than the parents. Whether a parent puts the kids' needs ahead of their own is also very important to a judge. There are no such things as parental rights. Just like using the term child custody, talking about parental rights is a way to turn a family court judge against you and ensure that your ex has the kids in his or her care. Instead, look at things from the kids' perspective. Put their needs and their perspective first. If you are in family court, you not only have to do that, you have to make sure what you say reflects that. Don't say my time with the kids. Say the kids' parenting time with me. Parenting time is the right of the kids. There are no parental rights. Don't say I need to make decisions about the kids. That sounds like you need to win and don't care about the kids. Say the kids need someone who can make the right decisions for them quickly. And here are examples of when I have done that. When you or your lawyer write an affidavit or talk in court, avoid using the pronoun I or say anything that makes you the subject of a sentence about parenting. Make the kids the subject of the sentence and the parent the object of the sentence. That not only puts the kids first, but shows that the parent is making the statement is the one that can meet the kids' needs. 3. Ignoring the best interest test. In making parenting decisions, judges are required to do what is in the child's best interest. That is not an abstract or airy-fairy concept. Both the Divorce Act and the Children's Law Reform Act set out specifically what factors the court must consider when deciding what is best for the children. Episode 59 went over them. So does my book. Look them up. Know them. Do not focus on factors that are not in the best interest test. Do focus on the factors that the law says the judge has to consider. Make sure in what you say and do that you're acting to make the best interest factors work in your favor. I'm going to touch on several of them in this episode. Make sure the judge knows that you are putting the children's best interest first by using the factors in the best interest test to help you make decisions regarding the kids. 4. Assume because you are a parent, you should get the kids. That's wrong. The 2021 changes to the family laws deliberately left out any presumption that the kids would be with either parent. Judges do not assume that the kids should be with their mother. They do not assume that the kids should be with their father. They consider only what is in the children's best interest. One of the factors in deciding that is the child's relationship with each parent. So a big factor is whether the child was close with each parent before separation. If a parent was not involved with the kids before separation, a judge will be suspicious that if that parent is asking for a lot of time with the kids after separation, that parent is just trying to reduce their child support. See episode 53. And my book for better ideas on how to do that, and not interested in actually parenting the kids. Parents can defeat that perception by being actively involved with the kids and having a great plan for raising the kids. The legal best interests of the child test requires a judge to evaluate each parent's plan and the parent's willingness to put that plan into action. 5. Being unsupportive of a children's relationship with the other parent. The legal best interest of the child test, which judges apply to make decisions about parenting after separation, specifically requires the judge to consider each parent's ability to support the child's relationship with the other parent. The same law also requires that the judge consider the ability of each parent to cooperate with the other parent. Essentially, that gives the behavior of each parent to support the other parent double the importance of the other factors, including double what a child wants. Also, judges are under a lot of pressure to stop parental alienation and to do whatever is necessary to achieve that goal. According to some social science research, being branded a parental alienator is worse than committing domestic violence and is the same as being labeled a child abuser. There are very few circumstances where a parent is legally justified in preventing the other parent from having a relationship with the kids, including spending regular time with the kids. In episode 75, I went over when a parent can legally prevent the kids from seeing the other parent and the potentially disastrous consequences for getting that wrong. Those consequences can include a court order that prevents the parent who did not support the child's relationship with the other parent from ever seeing that child again. If you are really concerned about whether the children should have a relationship with the other parent, you need to get legal advice fast to avoid a very bad outcome in court or arbitration. You can email me at john@schumanlaw.ca or call me at 647-342-6775. I referenced several other episodes in this episode. For more information about other family law topics, please subscribe, like this episode, and hit the notification bell. You may also want to pick up a copy of my book. In addition, you can get a lot more Ontario family law information on www.schumanlaw.ca and on my social media feeds. Check out my Facebook page, follow me on Twitter and Mastodon and @SchumanFamLaw, and find me on LinkedIn, Blue Sky, and Threads. You can email me at john@schumanlaw.ca or call my office at 647-342-6775. Saying a child should decide what relationship to have with each parent. Judges do not like it when one parent tries to make the children choose between their parents. Often a parent does that because the parent thinks that he or she can manipulate the child into taking sides. Kids should not want to take sides in a fight between their parents. Judges are very suspicious when kids take sides in a dispute between their parents. Judges also consider it to be very bad parenting to involve the kids in disputes arising from their parents' separation. There is nothing in any Ontario family law statute that says that a child of a particular age gets to decide with which separated parent that child gets to live. It is not until healthy children turn 18 that a judge can stop making parenting orders. Judges order teenagers to live with one parent, often over the teenager's objection, all the time. Despite what Article 12 of the UN Convention on the Rights of the Child says, many family court judges do not want to even hear the children's opinion, either out of concern about forcing the children to take sides or to prevent the children from being manipulated by parents, or to fear that they already have been manipulated. The opinions of older children that are independently formed are but one of many factors that a judge must consider. But if a judge believes that a child's opinion was not independently formed, but are the result of a parent coercing that child, things will go very badly for the coercing parent. That is another type of behavior that could result in an order that prevents that parent from seeing the children at all. 7. Inconsistent or unreliable behavior. Parents need to demonstrate consistency and reliability in their actions. This includes showing up for their parenting time, returning the children back on time for the other parent's parenting time, maintaining a stable home environment, and being involved in the child's life. Having a life that is chaotic is bad and can lead to reduced parenting time. Having a life that is chaotic because of substance abuse, gambling, or mental health concerns is much worse. Unreliable behavior can be used against a parent in court. In fact, the stability of the home environment and the ability of a parent to act like a parent are two factors that a judge must consider. Family lawyers and parenting professionals can help parents create a great home environment for their kids. If there are any concerns expressed about your parenting, or your reliability, or even your ability to meet the kids' needs, get to a good family lawyer to find out how to address those allegations without saying anything that will upset the judge. 8. Being careless on social media and messages. In today's digital age, social media activity can play a big role in parenting cases. Posting inappropriate content or engaging in online disputes can be detrimental. If one parent's social media posts suggest that parent has been engaged in behavior of questionable morality, or even worse, has been nasty to their ex online, that can come back to haunt the careless poster. If any parent does or says anything online that gives the other parent ammunition for court, it is almost certain that content will end up before the judge. Similarly, text messages, emails, and other online communication with the other parent or regarding the kids often ends up quoted in affidavits or in the evidence at trial. After separation, parents should assume that everything they send from their computer will be read by a judge, because it probably will be, especially if it is bad. Write all social media posts, messages, emails, and other contact like the judge is going to read them. And if you are uncertain about what a judge will like or not, speak to a lawyer first. But here's a hint. If you are disparaging the other parent, the judge is not going to like it. Conclusion. Navigating a parenting case in family court is undoubtedly challenging, but being aware of common mistakes and how to avoid them can make a significant difference. Always prioritize the children's best interests, put the child first, and cooperate with the other parent. Never put the children in the middle, and seek professional guidance to ensure the best possible outcome for your child. Never use the term custody. In my practice, I put a big emphasis on putting the children first and making sure they are protected after separation or in divorce. Please feel free to contact me at john@schumanlaw.ca or the phone number in the description. And of course, to get a lot more family law information on parenting matters after separation, or information about child support, spousal support, or other financial matters related to separation and divorce, and to understand how family court works, including an explanation of all the steps and the alternatives to court, get a copy of my book, The Guide to the Basics of Ontario Family Law. You can access it immediately on the iBookstore, on Amazon for the Kindle version, or you can download it for Kobo. Amazon can deliver the paperback version directly to your doorstep. Check me out on social media, and please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, Amazon Music, and many more. They're also available at www.schumanlaw.ca. Just look for podcasts in the drop-down menu. Thanks for participating in this podcast. We will get together again soon.